this is an ambush, and the prosecution, Your Honor, should know that this is a court of law. Court. Your Honor, all these advocates who are here, plus the accused person, had very important and urgent matters to attend to. But we chose to come before you, Your Honor, because of the respect that we have for the rule of law. Your Honor, Article 50, Sub-Article 1, on the rights of an accused person, is so clear. The right to a fair hearing. Your Honor, when the accused person, our client, is being used, misused, and abused by the prosecution, Your Honor, then it is your work to protect this right. Your Honor, we know very well that justice delayed is justice denied. This is a complete misuse of the court process, Your Honor, and public resources. And Your Honor, we pray that you dismiss this matter, and if possible, with costs.
Yes, to councils. 8 councils.
Eh?
To 8 councils.
To the 8 councils who are appearing before you, Your Honor. Your Honor, when we are being told that a witness is going to China and sufficient reason is not given to us, and there are other means of also attending this court, which can be virtual, Your Honor, then we pray that if possible, if we can proceed virtually, is also okay. Otherwise, thank you, Your Honor.
Holds the witnesses. Your Honor, we would have also wished to proceed virtually, perhaps after confirming what time the witness will be available for such a hearing, Your Honor. Your Honor, the last time the matter was in court, I believe on 2nd of October, the same was adjourned at the behest of the defense. The accused person was unwell. I am not sure if they provided documents, medical documents to confirm the same. Your Honor, we would not wish to occasion such a delay if the court is obliged to grant us a last adjournment. Prosecution undertakes to bring to this court, Your Honor, proof that the said witness is on official duty in China, Your Honor. We are praying for a last adjournment and summons to the said witness. Have considered the application made by the prosecution seeking for an adjournment in this matter. I've also considered the response made by the Defense Counsel objecting to the adjournment of this matter. Upon perusal of the file, the court finds that it will exercise its discretion in granting the adjournment for today. I'll grant the prosecution a last opportunity to avail the said witness, whom we've been told is out of the country on official duties. I would actually agree with the defense on that part, that they ought to have communicated the same so that they do not have to travel far. But as explained, to balance the rights of all parties. And from the perusal of the record, both parties have contributed to the delay in this matter. Therefore, I'll grant the prosecution a last chance to avail the said witness. So case is adjourned. We can have an earliest date.
You're not giving dates in which month?
We have January.
The very tail end of January. Oh, sorry.
Even tomorrow.
The investigating officer is present. Actually,
No, I was told that he is airborne, so maybe within this week.
So he's coming back.
Yes,
He's airborne. He's coming back.
yes, he's coming back, but unfortunately they cannot proceed virtually today. I think it might be okay.
so that we retain advocates who have traveled today.
Yes. Perhaps you could even give them at 12, so that the person rather is tired. 2 hours
So we proceed tomorrow at noon.
at noon. Yes. Okay.
Your Honor, we should hear her voice.
Your Honor, it is okay. The prosecution will be ready.
Thank you.
Yeah, we can retain the 2 hours.
Yes.
In the matter of Republic versus Nuru Okanga, as you are all aware, his persecution by the prosecution and the government is still ongoing, and today the prosecution had been asked to bring their last witness or all the remaining witnesses so that the matter, insofar as the prosecution is concerned, should be brought to rest, and the court will retreat to determine whether Nuru Okanga to answer or not. Unfortunately, we have been informed that their witness is in China and will not make it to court. We say it is unfortunate because, as you can see, Nuru had marshaled a battery of lawyers. We are about 26 lawyers who had come for this particular matter today, and we traveled from far away. We put aside our very many crucial engagements. You can say that Mheshimiwa Babu Owino here, who was also to be out of this country for official engagement, sacrificed and was in court today, and very many of us. This is unprecedented indolence, high degree of laziness. It is undesirable that a prosecution would fail to produce an expert witness even after having been given a notice for more than a month ago. We therefore have been allowed to come back tomorrow at 12 noon to hear and cross-examine the last prosecution witness. We shall be here because we know that the state is playing tactics with this case. They do not want to avail their witnesses for the simple reason that they do not want this matter to come to an end. They want to hold Nuru Okanga into slavery. They want to blackmail him using this matter because they know they have absolutely no case. In criminal law, if you have a good case, you avail your witnesses so that you can convict an individual. When you see a prosecution postponing cases on flimsy excuses as a witness being in China, it simply shows how weak their case is. It simply shows how unprepared they are. But we will be here tomorrow. To the witness, we want to wish you well on your way back from China to Kenya. We are 27 of us ready to engage you in a thorough cross-examination to determine what is this that you want from Nuru Okanga. My co-counsel.
The press. I'm Babu Owino, Nuru Okanga's counsel, together with other advocates who are here. Today, to our surprise, the prosecution has decided to not to avail a witness, a key witness, that is an expert witness in Nuru Okanga's matter. And this has gone against the rights of an accused person, the rights of our client, Nuru Okanga, as per Article 50, Sub-Article 1, right to a fair hearing. This is justice. This is justice delayed is justice denied. So our client is really suffering. He's traveling all the way from Mumias to Nairobi at his own cost, only to come and find that the prosecution is not ready to prosecute his matter. And these are the signs, the easy signs that showing us that the state has already lost this case. We further want the prosecution to avail a main witness who is the complainant in this matter, who is President Ruto. We want to cross-examine him.
Yes.
We want him to come to court because you can't do a court, you can't do a matter, a case without a complainant. Who is complaining? The DCI cannot complain, and the prosecutors cannot complain. We want a complainant in court, and that is the next application we'll be making. So let me give an opportunity to a fellow advocate, Counsel Connex.
My name is Connex Mwaro, and today we are really disappointed. We all made time to be here with our client, and only to be told when you're already in court that the prosecution will not produce the witness. This is actually to show us that the state is not ready for the case to continue, and it's actually an effort to curtail our client, to curtail his progress in the political fight against this, the infringement of rights of Kenyans. And we will not relent. We'll be back here tomorrow, and hopefully, without delay, we will have our witness and we'll be able to proceed with the matter. They wanted to push the matter to next year, but we will not allow that to happen. We need to move on. Our client needs to move. And as you can see, that means the state is really not ready, or even the case is not even a tangible case. So let's meet tomorrow, and hopefully we'll be able to clarify all this and clear our client. Thank you.
Yes, I'm informed by Counsel Babu. I had a look at the charge sheet, and the charge sheet relates to the Computer Misuse and Cyber Crimes Act. As all Kenyans know, this act was amended on 15th October 2025, the day that we lost Right Honorable Baba Raila Amolo Odinga. So this is one of the instances where Kenyans have been complaining that the very act can be used and misused by the state. So having had a glance of that charge sheet, I say that I'll make myself available for the defense of Nuru Okanga. For what he only did is to exercise his right of freedom of expression. That is a right that has been guaranteed in the Constitution, and that right cannot be curtailed. So we will be back tomorrow for the hearing and determination of this matter. And we know that Nuru Okanga, we will be gifting him with the Christmas gift, which is an acquittal in this case. Thank you.